Thank you very much, all of you once again for coming. This convention really is an inaugural convention that Chapter 4 and its partners hope will be an annual event from years to follow. This particular convention will be discussing the role of public interest litigation as a tool for social change and protection of human rights.
Public interest litigation, I'm sure for many of you around the room, know that it can be used effectively and it has a lot of significance.
Some people would not like to acknowledge that litigation is a legitimate instrument of social policy. And if an injustice is embedded in the fabric of the laws that society has made, public interest litigation may be the only way to redress those injustices.
It is very important that we engage all methods, that we raise the demand by Ugandans to demand for their rights.
Human rights abuses occur from the smallest to the highest levels. I think magistrates' courts should be empowered to offer redress in human rights cases.
Public interest litigation is not just for lawyers. It is a tool that has been used for a long time around the world, but also in Uganda, to protect the rights of every individual wherever they have been threatened.
Public interest litigation, if carefully thought out, well-timed, and strategically executed, can have real and lasting benefits for the advancement of social justice and the public good in society.
It's also a good place to think about the collective values that shape society. We get to interrogate our values normally through matters that are tagged as public interest litigation matters.
We should be careful, therefore, in assuming that the gap between public interest litigation and social transformation can easily be bridged. That gap exists where public interest litigation is not carefully thought out, is not well-timed, is not properly executed, and where, in fact, in some cases, it arises out of improper motives.
To me, it is very, very critical that we not only push for the legislation, but in terms of taking up public interest litigation for accountability to women.
We need to do PIL and other things hand in hand. If, for example, the denial of education ties into the lack of sanitary towels, why not? Why don't we take that campaign hand in hand with the community, on the radio, television, social media, to ensure that we achieve the human rights that our Chapter 4 of the Constitution talks about?
As the Honorable Member of Parliament has narrated them here, and as I listened to her, I was wondering and saying, do members of Parliament know their role? Because who is supposed to allocate money? Who is supposed to draw priorities and allocate money to whether girl or child or sanitary towels, all these things? It is not we. For us, we elect you, you go there to represent us.
There is a much more fundamental problem. You cannot have social change. You cannot build institutions without political change.
As part of this convention, we hope to institute an annual award for a civil rights lawyer. So for this year's award, the organizers of this conference have given the award to a lawyer who you have no doubt about his commitment about this kind of work, Mr. Ladislas Wakafuzi.
I think the conversation on public interest litigation should keep going, and there should be more and more cases brought for public interest litigations.
It appears from the discussion to me that the progress towards realization of gender and women's rights has sort of stalled. They have sort of hit barriers. The rights of women are also the rights of men and also impacts the rights of men. So if we have a majority of women in our society and they are not educated and they cannot work, then we don't have a viable workforce as a country.